Hey, everybody out there. Brett Amron of Bast Amron here.
And I'm Jeff Bast of Bast Amron. So today we wanted to talk about a topic that has come up with a number of uh, business owners in recent times. And actually, this is not unique to recent times, but particularly in this climate where a lot of businesses have either been mothballed due to the stay-at-home orders or have otherwise been severely impacted such that their revenues are either diminished or completely terminated. Many businesses have indicated an intention to just shut the business down and start a new business. And um, while that may not be, there's nothing improper about that. Is there anything that gives you concern about that, Brett?
Yeah, so we always, as you said, this is not necessarily new to the current crisis, but I'm sure we're going to see it more, and we have already started to see it. And that is, as you said, some businesses are mothballed, and some businesses are just under such a stress and such a strain of debt that they can't operate anymore, and it's just untenable. And so the clients will come to us and say, listen, I want to start a new business. I have an idea, and I'm going to start a new business, and here's what I'm going to do. Or they've come to us and said, well, we've already done that. And while that may not be an issue, it very well may be. And there's two different scenarios we could talk about today, how that could be problematic for the new business and the people that are involved both with the old business and the new business. One avenue is creditors of the old company sue the old company for whatever debt is owed, get a judgment, and then post-judgment can pursue or have the opportunity to pursue any assets that may have found their way over to either any individual or the new business. And the second avenue would be is if the old business filed a bankruptcy, a Chapter 7, where there is an appointment of a bankruptcy trustee who is a court-appointed, well, not a court-appointed, excuse me, a fiduciary in that capacity, and would have the obligation to go and pursue assets for recovery for creditors. And that trustee may, like the creditor in the state court in a judgment, would have the opportunity to pursue any assets that may have found their way to individuals or the new company. And so, Jeff, talk about, what happens in the situation when a bankruptcy trustee comes calling.
Well, yeah, I think if I may, I might just back up a little bit, and I think because a lot of the business owners who have come to us have indicated, well, I don't really have any creditors. There's nobody that's owed. But what a lot of business owners forget is they have a landlord. The landlord, they're going to just walk away from the lease. Landlords tend to sue. They tend to have lawyers on staff or on retainer because they have to file evictions. But the balance of the lease, there might be some unpaid wages, there will be vendors. That almost every business at any given point in time has creditors, and when creditors don't get paid, they often will sue, and those creditors sue and they get a judgment. And if creditors organize, three creditors with undisputed debts can put a company into bankruptcy. So even though a business owner may have no intention of filing a bankruptcy, their business could end up in bankruptcy. And when a trustee gets appointed, it's a trustee's job to find the assets. And it's not just what's there at that time, it's what was there in the past. And in Florida, like most states, we have a look back period for what's commonly referred to as clawbacks or avoidance actions. Trustees can go back in time and bring back or undo transfers of assets and rights. And so those are some of the risks associated with starting a new business when you haven't had proper advice and shut down the old business properly. The creditors of an old business or a trustee for an old business can pursue claims against a new business or either as a successor to the old business or as the recipient of transfers of certain assets or rights from the old business. So there are risks, and what we always advise clients is really the advice is to get advice, hopefully before they make those transfers, because a lot of these transfers can't just simply be undone.
So I would take it further back and say, even before, if you're even thinking of this idea, shutting a business and moving on to a new business, consult with a professional, because there may be factors that creditors and trustees look at, go back to all the formation of the new company. Who's involved? What's its business? What's it doing? If it's taking any property, is it going to pay for that property and provide Oldco with some value as well? So these are all questions that a professional should be able to help you with, and that things that indicia that creditors and trustees look at to determine, as you say, whether or not the new company is a successor, whether or not there was any transfers of property from the old company to the new company. Is the new company using any IP, any intellectual property of old company? Is it using any licenses that belong to old company? Some clients have come to us and said, well, we went to the landlord and we tore up the old lease and just signed a new lease with Nuco, and now we're operating. But it's a different business, and yeah, we're using the same equipment, but it's kind of a different business. Well, yes, you may have solved the issue with the landlord, but it could be problematic, and it may be problematic with other creditors of old company that are going to create issues, ongoing issues for the new company.
So it's important to, like as Brett said, get the proper advice, speak to your accountant, speak to your attorney. Hopefully it's somebody who has insolvency experience, but ask the right questions and get the right advice before you either shut down a business or start a new one.
Agreed.
Thanks.
Thanks, everybody.